1218 Mowry versus Pritchett. Counsel for Petitioner, you may begin when you're ready.
Thank you, Your Honor. Mr. Chief Justice, and may it please the court. My name is Nathaniel Mowry, and excuse me, I don't see the time up. So sorry.
I'm so sorry. Give me 2 seconds.
Sorry, I miswrote that. I'm so sorry. 13 and a half minutes. I'm so sorry. Thank you.
Mr. Chief Justice, and may it please the court. My name is Nathaniel Mowry, and I, along with my co-counsel Maclain Conlin, stand on behalf of Petitioner Mowry in the case at bar. At this time, I respectfully request 3 minutes for rebuttal.
Very good.
Thank you, Your Honor. Petitioner's right to equal protection under the Fifth Amendment, which extends from the 14th Amendment, was violated when Mowry was not accepted into Trinity Medical School while the school tried to fulfill the Native American Medical Care Act, or NAMC requirements set forth by the federal government. Excuse me. It is for the following reasons that the lower court's ruling should be overruled. First of all, this court should consider the new and evolving precedent of the Fifth Amendment when it comes into conflict with Morton versus Mancari. Second, even though there is a compelling governmental interest in the case at bar, NAMC does not constitutionally nor logically achieve this interest. And then finally, even if this honorable court does not find the preceding arguments persuasive, NAMC in no way achieves the narrowly tailored standard of this court. Moving on to our first argument, that being the consideration of the evolving Equal Protection Clause standards. As this court knows, Morton versus Mancari was based not off of race, but off of essentially political affiliation or national bias, saying that, quote, the preference as applied is granted to Indians not as a discrete racial group, but rather as members of quasi-sovereign tribal entities, unquote. But as this court has ruled in the case of Yiquo, as cited in Regents of the University of California versus Bakke, quote, the guarantees of equal protection are universal in their application to all persons within the territorial jurisdiction without regard to any differences of race, of color, or of nationality.
Mr. Mowry, do you concede that the tribal relationship to the federal government is different than the relationship than any other racial group?
Your Honor, we would still say that this is a racial preference because, as this court said in Rice versus Cayetano, heritage is a proxy for race, and inherently, NAMC does use heritage as it looks at one's grandparent or parent, Your Honor.
Well, I suspect that your friend on the other side may dispute whether it's a racial preference, but even assuming that it is a racial preference, doesn't the federal government have a special trust relationship to the Indian tribes that was recognized in Morton versus Mancari?
Your Honor, in Morton versus Mancari, this court recognized that the preference in that case was a political preference, Your Honor. For example, it was, I believe, the people who were alive living on the reservations, not necessarily their descendants, Your Honor.
I beg to differ. I'm sorry to interrupt, but footnote 24 of Mancari does talk about blood relations being part of the test of whether or not they satisfied enrollment into that BAA preference.
Well, Your Honor, Mancari also specifically said in its ruling, quote, the Indian preference statute is a specific provision applying to a very specific situation, unquote. Mancari essentially used the future precedent of Regents of the University of California versus Bakke. And
well, I'm sorry to cut you off, but what is that situation that Mancari was talking about, and why is the situation here different from that?
Absolutely, Your Honor. In that situation, it was dealing specifically with the Bureau of Indian Affairs, or the BIA. In the case of bar, we are looking at every single medical school in our nation, thus my co-counsel's 10th Amendment issue. So there is an inherent difference, Your Honor.
But couldn't Congress have rationally concluded that increasing the number of Native American doctors would be rationally related to sustaining tribal self-government, given the facts in the record here that the tribes had a dearth of doctors available on reservations?
Your Honor, possibly, but as we have proven, this is a racial quota, so it still needs to meet strict scrutiny, Your Honor. So even if this court does not find our first argument persuasive, we have our second argument, that NAMC does not meet the first prong of the strict scrutiny test, that being solving a...
Respectfully, before we get to the second prong, I think I'm still stuck on your threshold question of unless you're conceding it, which I don't think you are, Why is this racial? Is it just because there's a blood element? I think we discussed it already, was a blood element in Maclain. What about this makes it racial and not political?
Your Honor, as of this court's ruling in Rice versus Cayetano, heritage is a proxy for race. This court has never defined heritage as only the past 100 years or 200 years. It's just said the general word heritage. So this is heritage in this given instance, Your Honor, as it does pertain to one's individual grandparents or parents.
I'm sorry,
Wait, but-
Mr. Mowry does, oh, I'm sorry, Justice Monagas. Wait,
Please.
Mr. Mowry, you're saying heritage is always a proxy for race? I mean, if we had a law that was, created a benefit for someone whose parents were a resident of New Jersey, that would be a racially based benefit?
Your Honor, in that instance, it might not be racial, but in this given instance, it absolutely is racial, as it does pertain to a specific body of individuals, such as in Rice versus Cayetano, it was dealing with Hawaiians, and in this case, it's dealing with heritage. And as this
But in this case, I'm sorry, but in Rice, there was no tribe of native Hawaiians, and in this case, the law clearly defines the eligible recipients as people who are, members or have a parent who's a member of a federally recognized tribe, which to me is a, sovereign political body. Why is this more like Rice?
Well, Your Honor, respectfully, according to the facts of the record, it says related to. So it inherently involves heritage, Your Honor, because you have to be related to your grandparent or parent, or on the off chance you yourself are just Native American without your grandparents or grandparents being Native American. But in the instance of NAMC, it says that your grandparent or parent has to be Native American. So in that instance, it is absolutely a racial bias because it does go off of heritage, because it says you have to be related.
But can it be both? Can it be racial and political? I mean, I don't think that you're giving me a framework that's like mutually exclusive. Like the category of definition can be race and political, but the point, really, the thrust of it is how the law is applied. And it occurs to me that there's the Congress has made findings of fact that this is a political designation. And I wonder, my question to you, I guess, is how much deference should we give Congress when they say this is actually a political affiliation?
Well, Your Honor, first of all, I would say that NAMC does have political and racial elements, but because it has racial elements, we still need to look at strict scrutiny, Your Honor. And could you specify your question a little bit more later?
Yeah, no. I mean, I'm not sure that's right. It can't, just because it has racial and political, it doesn't automatically go to strict scrutiny. I bring you back to Maclain, which had obviously racial implications when it's talking about blood. No, but my question to you is more about when it's a political determination. The Maclain says that the focus is on the law itself and how it tribal governance, how the Indians interact vis-a-vis America, and the reality is that here Congress has said this law is political. This law should be governed in so much under Maclain. My question to you is: should we listen to Congress? How much deference should we give to Congress in this space?
Well, Your Honor, respectfully, Congress is not the body or the government body that is deciding if NAMC is constitutional or not. So I believe that the deference should be granted to this court, which is deciding if in this given instance it's constitutional or not, which I'm arguing.
Can I ask you a question? If it was limited to members currently enrolled in Indian tribes, would you still say it's a racial classification?
Your Honor, I would say no. I would not believe in that given instance.
So this is broader than that. This includes all those people plus other people, right?
Your Honor, I may have heard your question wrong. It was the
Currently enrolled members of Indian tribes, right?
Which would be considered Native Americans under NAMC, I believe. So yes,
Yeah, so you said that wouldn't be a racial classification, but if I include more people, it's actually more racial. That seems backwards.
If you include heritage, and as this court said in Rice versus Cayetano, heritage is a proxy for race. If you include heritage, then it is inherently racial, Your Honor. So,
why isn't it backwards? To include more people, it is now more racial, because my first group, you would admit, is all Native American.
Well, Your Honor, specifically, if we look at NAMCA, it says that one's grandparent or parent has to be Native American, not that the individual themselves has to be Native American. So the individual themselves they don't actually have to even understand the Native American culture for NAMCA to apply. And they
don't even have to be Native American ancestry, it sounds like. You just said.
Your Honor, they would have to be Native American ancestry. They might just not, they might also, excuse me.
Not Native American race, I mean.
Your Honor, they would still be the Native American race because NAMCA specifically says related to, Your Honor.
But I thought you had I apologize. I thought you had said that they don't necessarily have to be related by blood to their grandparent, but maybe I misheard you.
Like in the case of an adopted child, right?
Your Honor, I believe that would, first of all, be the minority of the time. And I believe also, according to NAMCA, it says related to, Your Honor. So it's a possibility we could exclude adopted children, Your Honor. But even if this court does not find our first argument persuasive, we have our second argument, that being that NAMCA does not meet the first prong of the strict scrutiny test, that being solving a compelling governmental interest. Now, it is not the argument of Petitioner that there is no compelling governmental interest. It is the argument of Petitioner that this precedent be extended to a compelling governmental interest in which the statute is highly and reasonably likely to achieve the given interest. And when we look towards the given case, we can see that NAMCA inherently harms Native American communities. The record specifies that petitioners—
What is the compelling interest that I understand you're conceding exists? What is that interest?
Your Honor, I believe it is the health of the Native American community, Your Honor.
And why is this not narrowly tailored to that, given the facts in the record that there are not enough Native American doctors?
Absolutely, Your Honor. We can move on to our third argument, that being that this given act is in no way narrowly tailored. So first of all, Petitioner recognizes that this court has held that a university does not have to extinguish every tailoring effort, just as long as, given the circumstances, the given statute is narrowly tailored. But this court also upheld in Bakke, and also it was reaffirmed in Grutter, that racial quotas are never allowed under narrow tailoring.
Counsel, if you want to use Bakke to support this argument, I mean, wouldn't you agree that Bakke is distinguishable from this case at hand? The interests were very different in our case as it was in Bakke. I mean, they're looking at increasing their diversity of a student population. So it seems to me that using that to support your case here, it's a distinguishable case, is it not?
Your Honor, respectfully, we would say that yes, there are differences, but this court has never upheld racial quotas. In every single instance, in the opinion of this court, this court has always said that racial quotas are never allowed because they inherently go against the Fifth Amendment, the Equal Protections Clause, Your Honor. So as we have proven, ancestry or lineage is a proxy.
But isn't my colleague's point that the interest in that case was diversity? So a quota may not be narrowly tailored to achieve diversity, but couldn't it be narrowly tailored to achieve more Native American doctors to address a health crisis?
Your Honor, this court did not specifically say in Bakke that it just because it was for maybe a less severe circumstance, racial diversity in a student body, that's why it wasn't allowed. This court made the general rule in Bakke and Grutter that narrow tailoring never allows racial quotas, Your Honor.
I'm sorry, Mr. Mowry, you're saying that there are two questions here. First, whether it's narrowly tailored, and second, whether it's a quota. And if it's a quota, we just skip strict scrutiny and say quotas are just prima facie, never allowed?
Your Honor, the part of narrow tailoring essentially has to do with the quotas. So that's what we're saying under that argument.
So why would we not look at the specific facts of this case to determine whether the quota here may be narrowly tailored?
Your Honor, I see that my time is about to expire. May I answer this question and briefly conclude?
Yes, please do.
Thank you, Your Honor. Your Honor, this court has always upheld that racial quotas are never allowed because they inherently go against the Fifth Amendment. And it's for the reasons presented to this honorable court that the lower court's ruling should be overturned. Thank you.
Thank you, counsel. We'll hear next from your co-counsel on the anti-commandeering issue.
And I may proceed, Your Honor?
Yes, you may.
Thank you, Your Honor. Mr. Chief Justice, and may it please the court. My name is Maclain Conlin, and I represent the petitioner, the state of New Storke, on the 10th Amendment issue. Our Constitution guarantees a separation of powers, and whenever the federal government tries to rob states of their sovereign authority, it violates our founding document. The Native American Medical Care Act forces states to enact a federal policy and does not leave them with a real ability to refuse. Congress can entice states to adopt a certain policy or a certain federal goal, but it cannot, consistent with the 10th Amendment and this court's precedents, coerce them into doing so. We present three arguments. First, under this court's holding in South Dakota versus Dole, Section 4A of NAMCA is unconstitutionally vague. Second, under this court's holding in NFIB versus Sebelius, Congress cannot coerce a state into adopting a federal program. And third, NAMCA does precisely that. Beginning with the first issue, Your Honors, in South Dakota versus Dole, this court said that, quote, if Congress desires to condition the state's receipt of federal funds, it must do so unambiguously, end quote. However, in Section 4A of NAMCA, we find a requirement that all medical school tuition rates must be, quote, yes, Your Honor. I'm sorry.
I'll jump in. I'm sorry, counsel. I'll jump in. I'm sorry to derail your argument, but I did have like a threshold question of whether the 10th Amendment argument is even viable. When I look at the Mowry decision that this court has decided, it says that we have plenary power to deal with the special problems of Native Americans. And it occurs to me that this is exactly what the law does, and it seems to be outside the purview of this 10th Amendment argument. And I just want to get your thoughts on that.
Absolutely, Your Honor. Congress does have plenary authority to deal with Native American tribes as quasi-sovereign political entities. However, this law goes far beyond that. It deals with the descendants of members of Native American political groups. It deals far outside simply the geographical boundaries of a reservation or the members of a certain political group. And thus, as a result, it does not fall under Congress's plenary power. And furthermore, Your Honor, even if it did, nothing in Congress's plenary power enables it to force states to implement its policies on its behalf, even when states disagree with those policies. NAMCA is both coercive and vague, Your Honor. And also, since I'm at this point, Your Honor, I'll go ahead and address that second issue. In NFIB versus Sebelius, this court said that, quote, that is true. That is, a statute can be unconstitutionally coercive, regardless of whether Congress directly commands a state to regulate or indirectly coerces a state to adopt a federal regulatory system as its own.
How can a benefit be coercive?
It's not the benefit itself, Your Honor. It's what would happen if a state did not choose to adopt that benefit. In this case, Your Honor, according to page 4, paragraphs, sorry, yes, Your Honor.
If they choose not to adopt it, isn't it just that they don't get the benefit? They're not being punished in any way, or there's no other federal funding that's being withdrawn, right?
Respectfully, no, Your Honor. While the time grant is being withdrawn, we do not contest that. But in NFIB versus Sebelius, Chief Justice Roberts specifically noted that some programs can be voluntary on paper and still be coercive in practice. We would argue that NAMCA fits that description perfectly. In this case,
NFIB,
the state says no.
I'm sorry to interrupt you, but in NFIB, there was existing funding at stake that states would have to leave on the table if they did not accept the expansion. Here, as I understand the law, there's some funding that states do not currently have. They can get it if they opt into this program. If they choose not to opt into this program, then they're in the same position they were yesterday. Isn't that right?
Respectfully, no, Your Honor. And we would disagree with, respectfully, your characterization of Sebelius. While there are some factual differences with that case, they are not dispositive in the case at bar. Chief Justice Roberts specifically noted that the standard is whether or not the law in practice puts a gun to the heads of the states. And in this case, Your Honor, according to page 4, paragraph 2 through 5 of the record, private medical schools that have chosen not to adopt NAMCA have experienced a 75% reduction in applications, quote, enrollment difficulties, end quote. And when a poll was conducted among many students at Trinity Medical School, most of them said if NAMCA was not adopted at their school, they would simply go to a different educational institution.
Counsel,
so essentially,
Counselor. Oh, I'm sorry, Justice Reardon.
Thank you. Aren't you missing the point? I mean, I'm thinking perhaps maybe Congress, the federal government is trying to incentivize the states to do something to save lives, because we have a statistic that Native Americans on reservations live on average over 5% less or 5 years less than the rest of the population. What do you say that this is a program to incentivize the states?
We would disagree with this, Your Honor, because in South Dakota versus Dole, this court said that something becomes unconstitutional when pressure turns into compulsion. Now, for example, in Dole, it only affected 0.3% of the typical state's budget. And in Sebelius, it was 10% of the state's budget. And this court held that it was coercive in Sebelius, but not in Dole. And in this case, Your Honor, a state medical school, a government actor, is faced with a 75% reduction in applications. So we would argue 75%.
Counsel, just because it's a 75% reduction in applications, I mean, this is only 4 schools, we're talking about four private schools, but also there's no indication in the record that those 75% reduction in applications actually reduced attendance, it reduced retention, it reduced actual admissions. I mean, what would you say to square that?
We would disagree with that, Your Honor, because of the study conducted by the Department of Education. That study found 2 things. First of all, medical schools that did not comply with NAMC experienced enrollment difficulties. And second of all, Your Honor, the surveys conducted by the DOE at compliant schools found that a large number of students in the existing student body would choose to go to a different school if their school withdrew from NAMC. So we would say, Your Honor,
I mean, is it the government's role to fill seats of private colleges?
No, Your Honor, absolutely not. But since these 4 private medical schools are the only ones, as far as we can tell, that do not comply with NAMC, what happened to them is indicative of what would happen to Trinity Medical School if it chose not to follow federal dictates. And
Counsel,
so we have to be because.
Counsel, I guess I'm a little hesitant to throw out an act of Congress based on one study that looked at 4 schools. But I want to ask a slightly different question, which is that one of the main rationales of our anti-commandeering doctrine is that we want political actors to be accountable for their own decisions, but not the decisions that others impose on them. So why is it not okay in this scenario to simply, allow constituents of New Storke who are upset that, their state is not offering free tuition to simply elect new leaders who will support, this plan? I mean, why isn't that sufficient here? I mean, we said that the political process was sufficient to protect state interest in Garcia.
We would disagree with that, Your Honor, because the same thing could be said in the Sebelius case. There you could have said, well, the political process will make sure that if a state doesn't want to go along with losing all of its Medicaid funding, people will simply elect different leaders. However, this court still said that because those state leaders were government actors, coercing them right now would still violate the 10th Amendment, even if in the next election they might be thrown out. The same thing here, Your Honor. While some state medical school officials will choose not to comply with NAMC and then perhaps be removed through an election, that does not erase the fact that today they are still being coerced into adopting a federal program in violation of the 10th Amendment. And furthermore, Your Honor,
isn't it the very nature of an incentive that receiving the incentive will be better than not receiving it, and by the same token, not receiving it will be worse? How is it possible under your framework to have an incentive that is very good and that is highly desirable, but is not coercive?
Absolutely, Your Honor. We could look at South Dakota versus Dole, where it only affected 0.3% of the typical state's budget, and this court held that it was not unduly coercive. This court has had to look at whether or not a law in practice actually does coerce states. Does it give them a real choice? In Sebelius, no, because it involved 10% of a typical state's budget, which is not easily recovered. Whereas in Dole, it was 0.3% of a state's budget, which is easily recovered. We do not dispute Congress's authority.
You think the government should essentially, if they're coming up with an incentive and they're worried that it might be too coercive, they should essentially make the incentive worse, and thereby less effective at incentivizing. Doesn't that then create much fewer incentives being given to the states in general? Because if the incentive is too good, it might be too coercive, and so we have to make sure that when we incentivize things, the incentives might be a little bit desirable, but just not that desirable.
We would say this court should continue to apply the standard it applied in NFIB versus Sebelius. We recognize that in some cases, Congress, while applying legitimate pressure, can at some points cross the line into compulsion. The standard is whether or not in practice, a state official has a legitimate, real choice of whether or not to comply with federal dictates. And you would argue that in this case, Your Honor, it's a clear-cut case. In the future, these cases might be harder to decide, even under the Sebelius framework. But here, Your Honor, when we're faced with a 75% reduction in applications, a reduction in the existing student body, and the possible closure of a medical school that does not comply with NAMCA,
Counsel,
we can see that in this case. Your Honor.
Yeah, counsel, I just, what do you say to the other side's argument that the state could just give the money to the medical schools, the state medical schools? I mean, both South Dakota versus Dole, Sebelius, these are about state budgets. This is for public medical schools. This is like a fraction of a percent if they wanted to like cover this shortfall. So I don't even understand this coercion argument. I mean, how do you respond to that argument?
Absolutely, Your Honor. And we would say that while the time grant is minuscule and we're not challenging that, the effects of the tuition subsidy do have disastrous effects upon the typical medical school's budget. Again, the record
But it's the
notes
state,
the
isn't
DOE
the
study.
proper unit the state budget?
We would say that in this case, Your Honor, the best unit possible is probably the state medical school budget, especially because we don't have any information upon the state budgets in this case. That was not raised by either party in the record below. All we know is how this affects the budget of state medical schools. And because state institutions of higher education are independent
Does it affect the budget of the state medical school?
Yes, Your Honor, it does, because according to the DOE study, medical schools that have not participated in NAMCA have experienced enrollment difficulties, Your Honor. And a school without medical students is a school that is experiencing financial difficulties. We can make that inference from the record. We can see that if there's a
drop in enrollment or just a drop in applications?
There's a drop in applications, Your Honor, and there's also enrollment difficulties, which implies a reduction in the existing student body. And furthermore, the Trinity Medical School survey found that if Trinity Medical School pulled out of NAMCA, there would be a significant drop in enrollment, Your Honor, which would have deleterious effects upon Trinity Medical School's budget. And it's a state institution, and harming a state institution's budget when it crosses the line from pressure into compulsion violates the 10th Amendment, Your Honor.
Mr. Conlin, would you like to quickly address your vagueness argument?
Oh, absolutely, Your Honor. Thank you. I appreciate that. In this case, Your Honor, Congress has told state medical schools they must keep their tuition rates at, quote, reasonable levels. However, it never defines what a reasonable tuition rate actually is. And while respondent might try and argue, well, the Secretary of Education can clarify that. Well, first of all, even if the Secretary of Education had the authority under the Constitution to make an otherwise vague statute thereby constitutional, the Secretary of Education, as far as we can tell, has issued no such regulations in the case at bar. The Secretary of Education could decide halfway through this next school year that Trinity Medical School's tuition rates are unreasonable and then remove Trinity Medical School from the program. Under South Dakota versus Dole, whenever Congress puts conditions on the receipt of federal funding, those conditions must be explicit. And in this case, the Secretary of Education has not fulfilled her constitutional obligation to make those requirements explicit.
Mr. Conlin,
Your Honor,
sorry, Mr. Conlin,
yes,
but that's a different lawsuit, isn't it? I mean, we don't have any facts about whether the Secretary has imposed, particular limits here, and whether the Secretary has claimed that, your schools or Trinity's tuition is unreasonable. I mean, why would that be proper to address here, given, as you said, the absence of information in the factual record about the standards by which the government is even judging this?
We would say, Your Honor, the Secretary of Education, we have not found any evidence of such regulations in the record. And furthermore, under the anti-commandeering doctrine, a grant must be both clear and voluntary. And NAMCA is neither one, and therefore it violates the 10th Amendment. Thank you, Your Honor.
Thank you, counsel. We'll hear next from counsel for the respondent.
May I proceed?
You may, thank you.
May it please the court. My name is Yannie Chau, and my co-counsel is Liang. Both of us represent Respondent Elise Pritchett, the Secretary of Education of the United States. At its essence, Your Honor, this is a case about satisfying a unique historical obligation to help Native Americans further their self-government by way of increasing physicians on reservations. This not only enables Native Americans to deal with their continuous healthcare issues, but also alleviates the large disparities between Native American healthcare and the general population. In support, respondent will make the following two arguments. First, the objectives of both Part Section 3A, the outreach program, and the requirement that the admissions procedure ensure that at least 5% of admitted students are qualified Indians are political in nature, consistent with Congress's plenary powers to deal with these special issues of Native Americans, and are entirely non-racial, pursuant to Morton v. Mancari, need to only satisfy rational basis. And second, assuming that this court does determine that Section 3A is a racial classification, it still satisfies strict scrutiny as its objections are undeniably compelling as conceded by petitioner, and the means employed by NAMCA to achieve those purposes are narrowly tailored to achieve those objectives. Now, Your Honor.
How does this law rationally further Indian self-government? I understand that it may further health on Indian reservations or for particular tribes, but how does it further Indian self-government in the way that was at stake in Morton versus Mancari?
Yes, Your Honor. What we can see is that Native American healthcare is crucial for the autonomy of these Native American entities. Therefore, what we can see is that in order to help these Native Americans achieve higher healthcare, we need measures in which will help the disparities that Native Americans on reservations are currently facing. And NAMCA does exactly that. So therefore, we can see that in this case, under the circumstance that it is a political classification in which NAMCA.
Well, what is the limit to that? Because the Bureau of Indian Affairs in Morton versus Mancari was clearly a government entity that was involved in regulating Indian tribes. But if your argument is that anything that benefits a tribe, like their health, ultimately winds its way up to affecting the government, is there any limit on laws or interests that Congress can protect for the tribes? There has to be some limit, I assume, on what's tied to Indian self-government.
Yes, Your Honor, we agree that there is a limit to which Congress can say, well, this is what benefits Native Americans. However, what we can see is that within that line, NAMCA still passes. As we can see that NAMCA isn't unreasonable in setting only 5% of the seats of Native Americans. Additionally, NAMCA isn't ensuring that all applicants who are qualified Native Americans under NAMCA are gonna be guaranteed admission to the university, which is what the petitioner Alex Mowry is arguing about.
But what is that? What is that limit, Counselor? I'm curious. Like, if we expanded this law, NAMCA, Congress did, and said, you know what, why limit it to medical schools? I mean, Native Americans are having, healthcare, socioeconomic differences throughout, their lives, and we need to have admission processes broader than medical school. It should be for all undergraduate institutions. So if we had an undergraduate institution requirement that allowed 5% of all Native Americans to be accepted, what have you, would that be constitutional?
No, Your Honor, despite the fact that I can't draw an explicit line to say how broad or how narrow this line may be, what I can say is that in this case specifically, because there is a compelling state interest to healthcare, and we can see that through the statistics that Congress has found through the shortened life expectancies of these Native Americans, that the 5% set aside because of NAMCA is rational. Therefore, we can see that because NAMCA falls under the is rational under the rational basis test, then it passes under a political classification. Additionally,
Ms. Chau, your friend on the other side has pointed to, I think, what he called our evolving equal protection jurisprudence. And I think he might have a point, because in Rice, we sort of cabined Morton onto its own facts. And we said that, the Bureau of Indian Affairs was just a very unique context. And I'm not sure that we've applied that same logic beyond that. In fact, we've said in cases like Rice and in Bakke and Gratz and such that, these kinds of categorizations, for example, I think in Wigand, one of the privileged groups was Native Americans. We said these kinds of categorizations are always subject to strict scrutiny. If Morton is your only authority here, I mean, how far can we really stretch it, given the wealth of case law, kind of to the contrary, that's developed in the meantime?
Yes, Your Honor. So to that, I have 2 points. So first, in regards to the Rice v. Cayetano specifically, what we can see is that in Rice, they were dealing with Native Hawaiians, which is significantly different from Native Americans. Native Hawaiians do not self-govern like Native Americans do, and therefore, because of that, we can see that Native Americans have a unique legal status from the federal government.
But
however,
didn't the relevant portion of Rice assume, for sake of argument, that the federal government was entitled to treat Native Hawaiians in the same way as Native Americans?
Yes, Your Honor. In the case of Rice v. Cayetano, the court did find that Native Hawaiians are analogous to Native Americans. However, the difference is the guardian-ward relationship. That is what is analogous. However, in regards to the self-governance, Native Americans and Native Hawaiians are different in that case. In this case, we can see that Native Hawaiians are still subject to the same level of legislation that other minorities are facing, for example, Black people. However, Native Americans, they're subject to separate legislation as they are treated as a quasi-sovereign tribal entity. And this falls in line with Congress and the Constitution, as it is both implicit and explicitly outlined this unique legal status for Native Americans. Therefore, we can see that because Native Americans have this unique legal status, that legislation for these Native Americans are distinct from precedent cases such as Rice and Bakke. Additionally, we can say in Rice
Well, counsel, I just want to interrupt you. If we disagree with you and we end up applying strict scrutiny, don't you lose?
No, Your Honor. So this brings me to my second point, in which first petitioner concedes the first prong of strict scrutiny, which is compelling state interest, and takes issue with the second prong, which is narrowly tailored. However, respondent believes that NAMCA does satisfy narrowly tailored, as NAMCA directly addresses the issue of the lack of physicians on reservations. In order to ensure that healthcare on Native American reservations improve, NAMCA's goal is to increase doctors on reservations. And by ensuring that at least 5% of matriculated students are qualified Native Americans, NAMCA falls in line with the IHS report found on page 2 of the record that concluded that individuals with familial connections to a tribe are more likely to practice medicine on reservations in the long term.
But counsel, I need to interrupt you again, please. I mean, that's, a hypothesis, a likelihood, but it's not a guarantee.
Yes, Your Honor. Respondent concedes that it is not a guarantee that these members are going to return back to these reservations. However, the point of NAMCA is that it is going to increase Native American doctors as a whole, which is the entire point. We're under the assumption that some of these Native Americans are more likely to return back to reservations. We are going to see that increase in Native American doctors.
Counsel, I think you're looking at the wrong thing here. We're not asking whether this particular program will help the government achieve its goals. We're asking whether there are race-neutral alternatives that are available and feasible that the government has, passed on. And I don't see anything in the record. I mean, point me to it if I missed it, but I don't see anything in the record showing that the government ever considered any alternatives to NAMCA, much less evidence suggesting that, the alternatives that your friend on the other side is proposed are somehow unworkable. Can you address that?
Yes, Your Honor. So I have 2 points on that. So first, if we turn to the court in Grutter, the court in Grutter found that narrowly tailoring does not require exhaustion of every conceivable race-based alternative. This signifies that although other alternatives may exist, it does not take into account the statistical evidence that Native American doctors are simply better suited to navigate the healthcare challenges facing reservation community.
Counsel, while that may certainly be the case, when we're looking at race-neutral alternatives, why is it that when you have a petitioner such as we have here, who has spent the time on the reservations, who has done the work with the populations, why is it such that we can't have a policy that instead just, requires an amount of time worked on reservations afterwards, or some other level of dedication that's race neutral? Why would that not still achieve the same goals? I mean, we have no guarantee, as my co-justice mentioned, that Native Americans will indeed practice on those reservations. So why is that not a viable race neutral alternative?
Yes, Your Honor, and that we have to turn into the question of effectiveness versus whether or not NAMCA is constitutional. For example, we can say that NAMCA is constitutional and add another clause to it. Under that circumstance, NAMCA is still constitutional. Therefore, we could for sure add another policy in which you are required to return back to reservations. However, that does not disprove the fact that NAMCA is not constitutional. Now, petitioner also brings up another argument in which they say that it is not narrowly tailored, as racial quotas have never been allowed in pre-precedent cases.
Before you get to the quota, I have a question about the scope of your argument. Suppose Congress found that a particular racial group other than Native Americans had disproportionately poor health outcomes and were underserved. would you find a law that was directed at a racial group other than Native Americans constitutional in that circumstance? Everything else about the law being the same?
No, Your Honor, under that circumstance, we would again have to turn back to the explicit and implicit mentions of the unique legal status of Native Americans drawn from the Constitution.
Well, that's what confuses me, because I thought the unique legal status of Native Americans went to your argument that we should apply rational basis review. But you're also arguing that you would win under strict scrutiny. So if you win under strict scrutiny, why is that not also true for other racial groups?
Yes, Your Honor, the reason why we say that we win under strict scrutiny is because it passes the second prong, which is narrowly tailored. The unique legal status of Native Americans can apply to both tests of rational basis and strict scrutiny, as it is just an obligation from the federal government, regardless of which test we use. Therefore, what we can see is that narrowly tailored is still satisfied. And therefore, going to my argument on the quota system in which the petitioner brings up racial quotas have never been allowed, Justice Testa and Chief Justice Van Oz correctly note that the only time racial quotas were not upheld was when diversity was the compelling state interest. Petitioner mentions that this court has never upheld racial quotas. However, that is because every single time a racial quota has been mentioned in this court was with a different compelling state interest. And that is a key distinction between the precedent cases and what we see here. As we can see,
sorry to interrupt, but how isn't the compelling state interest here really just diversity? You call it something else, but really what you're trying to do is get more diverse people in these hospitals so they represent the community that you have. It is ultimately diversity. How is it different?
Your Honor, in this case, NAMCA's goal isn't to achieve diversity in hospitals. Rather, the goal of NAMCA is to increase the number of doctors, of physicians on reservations. And in order to do that, we have to have a set aside for these Native Americans so they can return back to reservations. Therefore, ultimately, the goal of the different policies, for example, the difference in policies in Bakke versus the policy from NAMCA is fundamentally different. Additionally, we can see that
I think, I'm sorry, but it sounds like it's just semantics to me. You say that the goal is to bring in more people into the hospital. That's not true. The goal is to bring in more Native Americans to the hospital. You do that by a quota system, which is what you're arguing right now. That quota system is just really increasing the diversity of physicians at the reservations. Explain to me how that's not correct.
Yes, Your Honor, Respondent believes that is not correct, as we're not talking about the general population and increasing diversity in hospitals. Rather, what we want to do with NAMCA is increasing Native American doctors, which is a specific race, on reservations. So ultimately, we're not trying...
you said it was a race.
Your Honor,
Is it a race or is it not?
Your Honor, in this case, it is not race. However, under the circumstance that this court does find it is to be racial and therefore has to have a compelling state interest of helping doctors on Native American reservations, under that circumstance, then we would say that ancestry would be racial. However, our first stance is that it is not racial. So as of now, we're dealing with two separate issues. That first, if Native Americans were a quasi-sovereign nation, it passes rational basis. But under the circumstance that Justice Monagas was trying to question about on whether or not if it had a compelling state interest in diversity, we say that Native Americans are not trying to increase diversity in any circumstance. Rather, we're trying to solve the disparities that we're seeing on reservations. Accordingly, for the reasons set forth herein, Respondent Pritchett respectfully requests that this court affirm the decision of the U.S. Court of Appeals for the 14th Circuit. Thank you, Your Honor. I now turn over the issue 2 arguments to my partner.
Thank you, counsel. We'll hear next from your co-counsel on the second issue presented.
May it please the court. As my co-counsel advised you, my name is Liang, and I also represent Respondent Pritchett. And I will be arguing that NAMCA is not unduly coercive and does not violate the anti-commandeering doctrine of the 10th Amendment. In support, Respondent will make the following 2 arguments. First, the modification to the time grant program set forth in Section 4B2 of NAMCA on page 24 of the record is a traditional monetary incentive program long recognized and approved by this court, and it is not unduly coercive and undoubtedly meets the 4-pronged test set forth in Dole for evaluating the constitutionality of such conditional grant programs. And second, the conditioning of federal grant tuitions does not violate the fundamental federalism principles or the anti-commandeering doctrine of the 10th Amendment, because NAMCA does not command any exercise of sovereign state power. Now, Your Honors, with respect to respondents' first argument, as established in New York, this court has recognized that Congress has at its disposal a variety of methods short of coercion by which Congress may urge a state to adopt a legislative program. First, now, Your Honor, with regard to the court's decision in South Dakota versus Dole, the four-prong test, because petitioner really only disputes the second prong, which is that grant conditions must be clearly stated, we will primarily examine this prong. As both petitioner and respondent—
Before you get to that issue on vagueness, on the coercion issue, I understand your point that this is simply a benefit, monetary benefit, and that perhaps this court has not previously found that to be coercive. But given the facts on the ground that schools are being, in practice, destroyed if they do not accept this, how is that not a gun to the head?
Well, Your Honor, a couple points on that. First, respondent disputes this idea that schools are being destroyed if they do not accept NAMCA. With regard to the effects of this, petitioner mainly illustrates this through the Department of Education study, which respondent would like this court to note a few points on. Firstly, even if we were to ignore that the research conducted on NAMCA is mostly based on a one-year case study along with a limited pool of evidence from only 4 schools, even the very parameters of the study were flawed. Though it may seem compelling, all of the critical findings that petitioner relies on are much more smoke than fire. And as Justice Testa correctly points out, a 75% decrease in applicants is notably not a 75% decrease in admissions, meaning that when it comes to actualizing the economic—
But surely any school that had a 75% hit in applications would think we have a major problem here. Are you disputing that?
Well, Your Honor, it doesn't necessarily— there's nothing in the record that reflects how much that hit really affects the student body of these schools. So if we were to assume this is true, we can also look to the second finding of the Department of Education study, which is even less supported. There's nothing in the record that reflects how much this one standard deviation decline even is. And nor does it importantly indicate the quality of the doctors that the schools will end up producing. And this is not nuclear waste or a gun to the head. It's that it's much more comparable to say it's a gun toward a potted plant or a coffee mug. It's an unfavorable outcome, but nowhere near the severity that petitioner argues.
Counsel, question for you. Who bears the burden of proving whether there is or isn't coercion here? Is petitioner supposed to prove that there is coercion, or is the government supposed to prove that there isn't?
Well, Your Honor, the respondent believes that it is petitioner's role to rise to the level of proving there is coercion in the first place. We cannot just assume every single government program is coercive just from the onset. So yes, we would believe that it is petitioner's role, first and foremost, to first prove that there is coercion present. Now, a key distinction that petitioner misses here is that even if we were to entertain this outcome, that medical schools would start crashing, the states still do not hold any constitutional right to maintaining a competitive medical school. And if the petitioner were to argue that the closure of the schools was coercive or a gun to the head, they would have to make a secondary leap of speculation on top of their first, that the closure would also severely impact the economy of the state or the state as a whole to rise to the severity found in New York or Dole. Thus, even if petitioner is accurate in describing
I take your point that perhaps there's nothing in the record on that issue, but isn't it common sense that if every medical school in a state closes, that there's going to be severe financial and health related impacts to that state?
Well, Your Honor, not necessarily. Even if we were just to assume that every single school in a medical school in a certain state were closing down, first, that would be a large leap from the facts in the case. But even assuming that were true, it is not necessarily indicative that the quality of the economy or the healthcare of that state would begin declining. There's nothing in the record that would reflect that, because it's also possible that state doctors from other schools states would go practice in that state, or that the state itself is not even dependent on that medical school for a large sum of its revenue. And the states have avenues to explore even without medical schools, and such diversity already exists in state economies, as Justice Tutt noted previously. the incident of a school closing down does not independently constitute coercion. And further on that point, Your Honors, petitioner's argument that the budget of the medical schools is the correct standard is simply incorrect. Every single precedent case has echoed that it is the question of whether or not the federal government has given the states a reasonable choice. Even if it is coercive of the schools, it is not coercive of the states, which is the true constitutional question posed before this court today. Now, Your Honor,
may I ask a question about the facts? I think your elicitation of how this factual record is a little bit more complicated is very well taken. What if we, though, were just to assume for the sake of argument that it's all true? You know, this law, in fact, is going to cut down schools. It is going to lower the prestige. It's going to basically do this parade of horribles that the petitioner has said. If these things are true, for sake of argument, is this law unconstitutional?
Your Honor, assuming this scenario in which it is totally apocalyptic, every single school is beginning to close down, and the states are unable to run their economies without those schools, then yes, respondent would have to concede and say that is unconstitutionally coercive. However, that assumption only happens after several layers of simply assuming facts are true of this case, whereas the record is contrary to the matter. Now, Your Honor, turning back primarily to the Dole test, as focusing on the second prong, as both petitioner and respondent have quoted in today's argument, the parameters of NAMCA are clearly defined and outlined within the statutes themselves. And for the reference of the court, the relevant wording can be found in the appendix. The wording could not be clearer, and the requirements to be eligible are outlined explicitly. The reasonableness provision of NAMCA is not ambiguous, as the court in Dole held only that states must be cognizant of the implications of their choice in both declining and participating in a conditional grant program. So yes, NAMCA leaves reasonableness to the discretion of the secretary, but is not required to specify beyond that. In other words, so long as NAMCA makes it clear to states that the secretary has this authority, it surpasses concerns of ambiguity. And is not Congress's.
But so I want to know where I'm supposed to decide whether it's vague. If this is a question of contract between the state and the federal government, then how can you delegate the details to the secretary to be filled in later? That seems like a total like bait and switch, right? Like, doesn't Congress need to put it into the statute? So doesn't everything about, oh, the secretary can fix this with regulations, just wrong?
Well, Your Honor, respondent does not necessarily contend that it's all fixed because the secretary can regulate it at some later point. It's the argument.
Isn't it a shot against it? Because the secretary could set it really, really high, giving all the competing medical schools a huge amount of money because they take the money. And suddenly you're looking at like billions of dollars being given to all the other medical schools, and only the holdouts are, right? I mean, it's almost worse for it because it's like the delegation might actually mean maybe it's vague.
Well, Your Honor, respondent is mostly arguing on the idea that simply just delegating this authority to the secretary is not necessarily coercive in and of itself. It is not Congress's vagueness here, but rather they're granting autonomy to the states to tailor their outreach programs to their specific schools, those budgets, demographic and social climates, etc. And furthermore, as Justice Tai correctly pointed out, the petitioner does not substantiate their claims that Secretary Pritchett has failed the constitutional burden and would indeed be a separate issue distinct from the constitutionality. It does not make it vague because the states are importantly cognizant of their choice if they decline the program. They know that the secretary has this authority, which is the important distinction that Dole requires. And perhaps there need to be issues down the line that regard potential abuse of this power, but does not in and of itself determine constitutionality.
Well, counsel, I think, in Sebelius, right, there was a provision in the Medicaid funding that had said that, Congress could change the conditions or change the requirements at any time. And we held that really wasn't sufficient notice to or constitute a voluntary sort of contractual agreement with the states. I mean, why doesn't this run the same sort of problem here? I mean, just because it says, well, the secretary can create regulations. I mean, I don't know that a state could really foresee some of the whatever the secretary would be doing here.
Certainly, Your Honor. So in the case of Sebelius, this court understood that the provision of being able to change these grant conditions at any time was unconstitutionally coercive. However, there are a couple key distinctions here. First is that the court in Sebelius held that it was only unconstitutional after the conditions had been changed to an egregious amount. So in Sebelius, it was because they decided to expand what qualified as a needy person under the ACA to a much greater amount of the population, which fundamentally changed the understanding that states and the federal government had of this program of Medicaid when it was first, the contract, so to speak, was first signed. In this case, this would be a later issue. And second is that the states are still cognizant of their choice in that this could change. But as of right now, it is a constitutional program because one, it has not changed. And more importantly, that second, they are recognizing all of the effects of the program as is. So essentially, we are in the state. Essentially, NAMCA is analogous to Medicaid before all of the before the lawsuits in Sebelius, where it was constitutional. Now, Your Honor, moving to the case of Prince, distinguishable from precedent like Prince and New York, NAMCA does not tell state officers what to do, but instead gives them an offer. All of these commands that Petitioner is outlining are conditions upon receiving the NAMCA grant money. The federal regulatory scheme can be rejected by the states, unlike in Prince. Another clear distinction
is there any amount of money at which you would concede that the program becomes coercive if Congress just kept upping the amount that states could receive by opting into this, or is it just limitless?
Well, Your Honor, we don't really take issue with the specifics of the monetary sum given to the states, but let's say that there was a Department of Education study later down the line that said if Congress gives, let's say, $5 billion to every school, not even to subsidize tuition, but just because, then we could find that that might indeed be coercive. However, that is not what we see in the instant case. So
why would that be coercive, but this one isn't?
Well, Your Honor, because of it would depend on the Department of Education's findings regarding that. If we found that no medical school and by proxy none of the states, importantly, would be able to continue functioning while rejecting this program, let's say this new NAMCA program, then that would be unconstitutionally coercive, as it does not offer these states a reasonable choice, as the choice between, for the states, survival and living is no choice at all.
Well, why is the standard that they can't function versus they can't function on equal footing with other states that do choose to receive this generous benefit?
Well, Your Honor, to answer this, we can turn to precedent like South Dakota versus Dole, where it may indeed be argued that states that reject the 5% in federal highway funding would not be on equal terms, because the point of the programs of placing conditions on the receipt of federal funds is intrinsically that these conditions have to induce some sort of compliance. There will always be some level of pressure exerted by the federal government. But this court has always understood that power of Congress. It only becomes unreasonable when it does not offer the states a choice between accepting or declining the program. So in this case, we see that states can still reject the program if they decide that the competitiveness of their medical schools is not a particularly important issue to them or some other distinction thereupon. However, the fundamental, the intrinsic nature of NAMCA is that it offers states a choice. And accordingly, for the reasons
set forth, the line that you've drawn here for when it becomes coercive lies in the downstream effects rather than what's actually in the policy itself. And so how is a legislator supposed to take that into account when they're creating a policy, when those effects might be unexpected and they can't predict all the effects that come from it?
Chief Justice, as I see my time has elapsed, may I ask for a time extension to answer the Justice's question and then briefly conclude?
You may. Please answer her question.
Thank you. So, Justice, in order for the legislators to consider all of these effects, we agree. And indeed, this argument falls in respondents' favor, as it means that the more downstream the effects are, such as perhaps closing of these medical schools or even worse, decline of prestige leading to decline of faculty or anything that the petitioner will claim, is far too downstream for lawmakers to properly anticipate. So in order for this court to properly consider the constitutionality, we must examine the effects directly measurable. And accordingly, for the reasons set forth herein, respondent respectfully requests that this court affirm. Thank you, Your Honors.
Thank you, counsel. Do we have rebuttal from the petitioner?
Yes, Your Honor. A 3-minute rebuttal, please.
Please proceed.
Thank you, Your Honor. May it please the court. Because NAMCA forces state medical schools to commit racial discrimination, it violates both the Equal Protection Clause and the 10th Amendment, beginning with the Equal Protection Clause. In Morton versus Mancari, this court held that giving preferences to members of Native American tribes living on Indian reservations was a political classification and not a racial one. However, in Rice versus Cayetano, this court held that giving benefits to the descendants of a political group qualified as a racial classification. As the Chief Justice pointed out, in Rice versus Cayetano, this court treated Native Hawaiians as identical to Native Americans. And it said that because the benefit was extended beyond that political group to their descendants, and because ancestry was a proxy for race, this court held that it was a racial classification. As this court said in Loving versus Virginia, as cited in Bakke, quote, "This court has consistently repudiated distinctions on the basis of ancestry as being odious to a free people," end quote. Now, turning to the issue of narrow tailoring, in Bakke, this court categorically said that racial quotas cannot be narrowly tailored. Now, our friends on the other side tried to argue, well, that was a different compelling interest. And if it's a really good reason, then you can use a racial quota. However, this court's prohibition in Bakke was categorical. It did not say, if you have a good reason, then this prohibition does not apply. It says, quote, "To be narrowly tailored, a racially conscious admissions program cannot use a quota system," end quote. This uses a quota system, and therefore, under Bakke, it cannot be narrowly tailored. And finally, to address race-neutral alternatives, page 15 of the record lists a variety of race-neutral alternatives that were not even considered by Congress. Now, turning to the second issue, the 10th Amendment, Your Honors. Now, opposing counsel tried to argue that the DOE study didn't say there would be any problems with existing enrollment. However, this is simply not true. The study explicitly said that medical schools that did not comply with NAMCA experienced enrollment difficulties, and according to the surveys done at Trinity Medical School, medical schools that do not comply with NAMCA will likely lose the majority, if not nearly all, of their existing student bodies. They also tried to say that the text of the law is all that matters and not the downstream effects. However, in NFIB versus Sebelius, Chief Justice Roberts specifically said that a law can be voluntary on paper and still be coercive in practice. This court must take into account the coercive effects of NAMCA in coming to its decision. They also tried to say that this law was coercive of state medical schools, but it was not coercive of states. However, in Prince versus United States, Congress forced state and local law enforcement officers to enforce a federal gun control law. And this court held that because state actors, state officials were involved, the state was by definition coerced. In the same way here, state medical school officials are being coerced, and thus under Prince, by definition, the states are being coerced. Because NAMCA forces state medical schools against their conscience, against their better judgment, to engage in widespread racial discrimination, it violates both the Equal Protection Clause and the 10th Amendment. And we ask this court to strike down both sections today. Thank you, Your Honor.
Thank you, counsel. Case is submitted. Well, I'm not sure what happens next or if I'm supposed to usher it in. So maybe we could have a few moments to finish any remaining things on the ballots.
Yeah, so judges can go camera off until they've completed their ballots, and then we'll resume.
Great, thank you.
Before we begin with justice feedback, I just want to say that concludes our final round for the NAMC National Tournament. So congratulations to all, and a very big thank you to our justices today. I think I want to make sure that the competitors understand the formidable panel of judges that they were facing today. So before we get into feedback, I would ask that each of the justices just give a brief overview of your background and some of the highlights of your career, and then we can go into feedback. Thank you all. And we can start with Chief Justice Van Os if you would like, or pass it off to someone else.
Sure, I can kick it off. Great job, everybody. My name's Trenton Van Os. I'm an attorney at Gibson Dunn. I was a law clerk for a few years before joining Gibson Dunn, first on DDC for Judge Dabney Friedrich, then the 11th Circuit for Britt Grant, and then on the Supreme Court for Justice Kavanaugh. Maybe should I jump into feedback, or are we kind of going down the line first?
Let's go down the line. Next on my screen, let's have Justice Monagas. Sorry.
Yeah, no, perfect. Good afternoon, good evening, everybody. My name is Enrique Monagas. I've been practicing for over 15 years. I graduated from Berkeley undergrad and Berkeley Law School. I also worked at Gibson Dunn and Crutcher before I worked for the Department of Justice, and now I work for Southern California Edison Company in Los Angeles, California.
Thank you so much. We will now hear from Justice Testa.
Hi, everyone. I'm in my final year of law school. I am our Moot Court Vice President and our final bench winner from this past year. So great job, everyone.
Next, Justice Tutt.
Well, hi, everyone. So my name is Andrew Tutt. I'm an attorney in Arnold and Porter in Washington, D.C. And I've argued a few cases in the Supreme Court, including Torres versus Texas, a case about state sovereign immunity, a case called Health and Hospital Corporation versus Talevsky, a case about the spending clause in Section 1983, and then most recently a case called Dupree versus Younger about the federal rules of civil procedures. So not a particularly interesting topic there, but yeah, and that's my background. I practice Supreme Court and appellate at Arnold and Porter.
Thank you so much. Next, Justice Tai.
Hi, everyone. I'm Tim Tai. I just finished my second year of law school at Yale Law School. So have not really had any career highlights yet, but I think, we're in the presence of some really, really great litigators here, and I'm just excited to hear what they have to say soon.
Thank you. Next, Justice Pigeon.
Yeah, I think I'm certainly the least esteemed on this highly esteemed panel. I graduated from UC Santa Barbara last year and co-founded the Moot Court program there, and I'll be headed to law school next year. So that's where I'm at.
Wonderful. And then last but not least, Justice Reardon.
Thank you, and good afternoon, good evening, everyone. Great job by the students, really formidable and just wonderful to hear you all. I am a solo practitioner in Windsor. I practice in the area of probate, special needs, estate planning. I am an instructor for the National Business Institute and serve on the board of National Association for Elder Law Attorneys. I've been judging Moot Court, I think 2.5 years now, and always a pleasure to watch the caliber of the students. Really, it's wonderful to see.
Thank you so much from all of our justices. Now we can move into judge feedback. And we will, yes, this session is being recorded.
Great. Well, I guess the first thing I want to say is just fantastic job. You can tell how much time and effort went into preparing for this. All of you were incredibly fluent in the cases and the facts, knew your arguments, and did a fantastic job responding to a lot of questions from the panel here. I did a little moot court while I was in law school, but was smart enough to give the oral argument to my partner. And so what you guys are doing here really takes some bravery, and I know a lot of work and preparation. So awesome job. I'll give a little bit of global feedback. I think one thing that I appreciated that everybody did very well, I think, was to roadmap your arguments. You had your intro down and you sort of let us know where you were going to go with the argument, so we knew what to expect and could have that in the back of our mind as we were asking you some questions. One area that is always really, really difficult, and I was impressed with the way you handled it, and I think this is something that there's always room for improvement for, and it's really, really difficult to get it down to a science, is trying to get back to that roadmap when you get derailed with questions. So it's really, you want to answer the questions that are being given to you, and you want to make sure that you're responsive to the justice's concerns and be sure that you're actually, giving the answers that are going to win the case. But at the same time, you don't want to get sidetracked on an issue that maybe isn't your strongest, or you just don't want to focus on for whatever reason. And you really got to get back to your primary argument. I think that's something that I could see the ways in which you were doing that, and I think you did it really skillfully, and that's something that always I think can use a little bit of fine tuning. But again, fantastic job. It was a pleasure to be able to watch this, and thank you for all the work that went into it.
I can go next, just in order of introductions. I have such little feedback. You guys were top of your class, fantastic, amazing. Like I said, been litigating for quite a while. I've done quite a few oral arguments before the state court of appeal and the federal courts of appeal. You guys could be practicing lawyers right now, which is kind of incredible, considering you haven't graduated high school, haven't gone to college, much less go to law school. So I really hope you pursue a career in the law practice, because you guys would be fantastic. I'm sure all the justices out here, if you're looking for a professional resource, like find us on LinkedIn, be happy to support your career any way possible. In terms of your advocacy, I mean, the only feedback is good feedback, which is to say that obviously the mastery of the arguments, but also the mastery of knowing what to concede and what not to concede. That you guys did a very, very good job on that. And it's something that's very often lost on litigators. You just want to stick to certain things, but sometimes you could just tell by the tone of the bench you've lost something, and you've got to be able to give it away in order to win. And you guys all did that very well.
I can't remember if I was next, but I may have been. I thought you all did a fantastic job, and similar to what I've said before, if you were to step into a collegiate moot court competition now, you would be up there with many of the other law students. I just have a few individual points for you all. Nathaniel, I think you had a very confident presence. And you really get those points across when you come across as that confident. I think the only constructive criticism I may have is if you are representing a petitioner, especially an individual petitioner, you can refer to them by their name, Mr. or Mrs. or their actual name, really personalize that individual that's, claiming a constitutional violation, right? And the other thing I would say is you want to try to avoid saying I am arguing or I believe. You want to kind of bring it back to the we or, Ms. Mowry or however you would like to refer to that. But excellent job. Maclain, I mean, all four of you, your presence and confidence was great. I think you had a wonderful pace and used record sites appropriately. I thought you had excellent pauses, which is something, we always recommend that take a minute, pause, think about how you're going to respond before just jumping into it. And I appreciated your rebuttal. It really made us realize you were listening to everything that was said in the other side's argument. Yannie, again, poised, confident. You answered every question directly for the most part, which I always appreciated. There was only one time I thought you may have skirted the issue, which was the diversity question that we were pushing you on. So again, similar to the justice's previous comments, you can concede certain things and still bring it back to your point and make it just as effectively. And then lastly, Davis, also, I mean, I love the fact that most of you, I think almost all of you stood, you were excited to be here. The only thing I would say, Davis, is maybe the hand movements. In some instances, we usually recommend or try to have students use less hand movements if they are standing. But other than that, fantastic job. I learned so much today also through listening to your arguments that I didn't even know.
I'm happy to jump in here. As everyone said, really, really great job. I mean, like the federalism stuff, this is stuff that you are learning in your first year of law school and your constitutional law class, or, depending on what class you're in, you may not even learn about anti-commandeering all 3 years of law school, at least not at Yale. But just in general feedback.
You learned other law at Yale?
Well, you know very well exactly how much law we learn here. I've seen both of these teams before, so I know I've said this already. Just watch your pacing. Some of you, I could definitely tell everyone has improved since the first round I saw each of your teams, but just be mindful, that you're not speeding up too much when you're getting hammered with questions. I think there's a bit of a tendency to have this sort of formal tone, and it might depend on what court you're in, but, more conversational, helping the justices reach the right answer, rather than just like, I have my points and I'm here to make them and I will get all these words out, so just be mindful of that. Another thing, kind of across the board, some of you did this more than others. Be mindful of sort of like filler words, like we can see that X, Y, and Z. And also, I think some of you would begin every response to a question with, yes, Your Honor. Just try to avoid, these filler words, especially don't say yes, Your Honor, if the answer is in fact no, because then it kind of gets a little bit confusing. And one other thing is just, put your strongest arguments first. So there were a few times where you would roadmap your arguments and I would be like, I wonder why that's the first point they're making. And so just think about what are your strongest points and lead with those, because otherwise you're going to let us, dig you into a hole for a point that may not even really matter in the long run. But otherwise, really great mastery of the factual record. Facts are always going to be one of the most important things, and you have to know them back in, like the back of your hand. And all of you really, really, clearly knew that, which is not surprising given that I'm sure you've all argued this a dozen or more times by now. And yeah, really, really good mastery of the material, and very, very impressed with all of you. So congratulations on making it to the finals.
Well, I don't mean to just jump in front of anybody, but I can go next. So just going to echo what everybody's said already. This was just such a pleasure to judge. And I'm just going to basically make more emphatic versions of everything that's already been said. So first thing, I'm going to make the more emphatic version of just how impressive I find this to be. So I didn't know where the Supreme Court was in the hierarchy of courts when I started law school, for instance. So literally even to just understand sort of how lawsuits work and how the Supreme Court does what it does, was not something I was familiar with until I got to law school. So you guys are way ahead. Even, I know that you guys probably don't have the super detailed understanding that we eventually get, but just to even be able to speak intelligibly about, all the different sort of side concepts, just to get to the middle part, the meat of this case is quite extraordinary, and just blows me away. And I'll just say everybody's poise is just sort of incredible. I mean, you have adult professional attorneys kind of sort of grilling you, asking the hardest questions we can come up with, trying to knock you off and knock you down. I'm asking you the same question I would ask you if you were in fact a professional attorney arguing this case to me. And so, you're not getting any kind of sugar-coated questions, at least not from me. And I imagine not from the other judges either. And these are just incredibly hard questions. And I think especially given how much of, at least I find, arguing, for instance, in the Supreme Court, how much I draw on knowing a lot of law. I know a lot of law. And you guys are being asked to sort of do this with just a couple of cases and sort of make these sophisticated arguments. And it blows me away how close you guys are to where we really are in terms of trying to figure all this out. So just the intellectual sort of horsepower of the litigants, I think, is just something that I wanted to remark on. So I did. And then the other thing I'll say is that, when I argue cases, the cases I've argued in the Supreme Court, every single word that I said was pre-planned, basically. Many of my answers were read off of sheets of paper that were in front of me at the podium. So in case you want to know the secret magic of it. And that is because it is not a confession, and it is a high stakes thing where you want to get the exact way that you say it exactly right. And I think you guys will all sort of grow as attorneys and sort of see, you guys were all fantastic today, but you guys, I'm so glad we're recording this, because when you graduate from law school and you see your performance here, you're going to see both how impressive what you did was, but then also be like, oh man, if only I'd known so much more law or had so much more like experience. So it's like going to be really, really fun. But I don't know. And I love to do that. I love to go back and look at like how I've grown and changed and developed. So I don't know. Those were my comments. They're pretty general in nature. You want more specific comments, find me on Google. I have an email address there. But yeah, just thanks for the opportunity to sort of get to judge you guys.
All right, and I'll just hop in to say, I agree with everything that's been said. I left comments on my ballot, and so I won't repeat them here, but I think that you've gotten some fantastic feedback, and you have a really great panel here, and so don't waste this opportunity, because this is how you start. This is how you start getting to know people, and this is how you start making connections in the legal world. And so really great job, everybody. And regardless of the result of this round, I hope that everybody feels very, very proud of what they brought here.
And I really don't have much to add. I mean, my esteemed colleagues have said everything that I felt and that I observed. I just would encourage all of you to continue with moot court, because if you're this good now, I can only imagine what you're going to turn into, not just as competitors, but also whatever your career path, the command of the facts, being poised and not getting thrown from your game, and staying, cool and calm and collected can only serve you well, no matter what path you take. So wonderful to hear your arguments and to see you all, and good luck. You all did a great job.
Thank you to all of our justices for their feedback. We are going to proceed into the award ceremony, but before we do that, one more time, thank you so much to all of our justices here today. If you have judged multiple rounds for us, if this is the only round you are judging, we cannot be more appreciative truly of your time and the time that goes into preparing, and how generous you've been to all the competitors, and especially us here at NAMC. So we are truly so thankful. We hope that you come back and join us for next season, but of course that's in the future, but thank you for the time being. You are completely welcome to leave the Zoom if you would like, or we also have the award ceremony starting around 7:30, although we ask everyone to be here at 7:15. So one more thank you all, and you can send off thanks in the chat if you would like, and please stand by before we start our award ceremony.